All right. Greetings. My name is William Morris. I am here with part 2 of a series on how to draft patent applications dealing with Section 101. And in part 1 of this series, I basically took a very, very cynical approach. Or I presented a very cynical approach, really almost nihilistic, sort of a nothing matters, everything is worthless kind of idea that said, look, the rules are meaningless. Judges are going to do whatever they're going to do. You're better off just treating complying with them as a sucker's game. And in fact, you should sort of throw it back in the face, proverbially, of the courts by being more abstract, so that it won't appear that you have an application that is familiar to the fact finders, or that for some other reason they might think is against their policy preferences for what should and shouldn't be patented, because that's really all it is, right? That was the approach from part 1. And as I mentioned in part 1, I don't think that's right. And in this part, I'm going to explain why I think that doesn't make sense. And essentially, the cynical approach, it has 2 premises, right? And both of those premises, I think, are incorrect. So the first premise in the cynical sort of nihilistic approach is that the rules are meaningless. And okay, so subject matter eligibility law is really, the rules of this are bad. I'm not necessarily talking about policy. I think you can make a strong case they're also bad as a matter of policy, but I mean they're bad in the sense of they're ambiguous, they are incoherent, they're incomplete, they can be unpredictable, but that's not to say that they can be ignored altogether, that they have absolutely no meaning, which I think is what being very cynical about it and saying I'm not even going to bother, I think that's what that's premised on. Because when you look through the cases, one thing that does seem to be reliable in terms of establishing eligibility is including low-level implementation details of an invention. An excellent example of this is Berkheimer versus HP. So in that case, you had independent claims that were found to be ineligible, but there were dependent claims that recited specific ways in which the invention's objectives were achieved, and the Federal Circuit pulled those out and said, yeah, these survived the Section 101 challenge. And that's kind of a running theme in their decisions. So I mentioned EnFish in part 1, and one reason I gave was, well, hey, EnFish didn't talk about a specific kind of data that the court might have found to be familiar, and that's why, if I was being very cynical, I would say, that's why it was found to be eligible. However, EnFish also did something else, which was they recited very specific details in the data model using actually means plus function language, which I think has a reputation as being something you should avoid because it does require a very high level of detail, right? It's tied specifically to specific structure for a computer, that's algorithmic structure in the specification. And in fact, that is what they said in the decision. They said, look, this is because we have a lot of detail in these claims about this data model that we're giving, that we're saying that this claim is eligible. Another case is Finjan versus Blue Coat. This is another one. So it was a computer security case about finding malicious files, basically antivirus software. And this one's another interesting one because previously there had been a case of Intellectual Ventures versus Symantec where the Federal Circuit said, hey, antivirus or virus protection is an abstract idea. And so why would you get a good result in Finjan? And the answer the Federal Circuit says, so they did find it to be eligible. And they said the reason their claims to computer security invention included a new kind of file, and it recited specific steps for using that file to achieve the desired results. In these cases, it does seem that you can, in fact, by reciting sort of low-level details, get over eligibility, even for the type of invention that has already been found to be ineligible, like you have in Finjan. And so, yeah, there's the cynical approach you can look at it, but you can also say, all right, well, cynical is one thing, but if I don't want to be just cynical and say, oh, I throw up my hands, there's nothing you can do, if you want to actually get a good result, know what you're doing, and be able to come up with good strategies, I think understanding that there are some rules that seem to sort of flow through, and that one of them is including the sort of low-level details that you might have in a computer-implemented means plus function language, or that you have, which you've got like a specific kind of file or a specific kind of linking structure that you had in the Berkheimer case, that this in fact can give you eligibility. And you don't have to just say, oh, it's, there's nothing, there's no predictability, there's no control, because we've seen that the Federal Circuit in fact has found things to be eligible when they do have this kind of information. And I will say in my own experience, so I've never argued this at the Federal Circuit, but I have argued at the Patent Trial and Appeal Board, and when I've argued it at the Patent Trial and Appeal Board, I have been able to succeed in these cases. And I've also done pre-appeal briefs with the means plus function language, and again, I've been able to succeed with this. So I would say from a practical standpoint, cynicism doesn't really get you super far, especially if you're already in it and you already found the 101. First premise, I guess, to sum up the first premise for being kind of very cynical, world-weary, is essentially that the rules are meaningless, nothing matters, it's all a matter of policy. And the problem is that I don't think is actually true. And even if it is, even if you can make the argument, which again I think is overstating things, if you're already in a 101 situation, you need to be able to say something other than, oh, it's so unfair. You need to actually be able to make a coherent argument. And I think you can do that by using kind of low-level implementation details. And I gave some case examples of that. So that's sort of the first premise of the cynical approach, and it's also why I think the first premise of the cynical approach is wrong. The second premise of the cynical approach, so I said basically, all right, in the cynical approach, what you do is you opt out, right? You try and avoid it entirely by recasting your invention as something that you don't think is going to trigger a 101. And the problem with that is it does not actually work. Or let me put it this way, maybe it works sometimes, maybe it works other times, but it's not particularly reliable, and it is not costless. So let's start with the not particularly reliable. In principle, you can't do this, right? So for instance, even Alice recognized that at some level, all inventions embody or use or reflect or rest upon laws of nature, natural phenomenon, or abstract ideas. They just do. There is always an incipient 101 issue in every case. And so to say, oh, I'm going to avoid it, no, you can go to you can try and reduce the risk that someone will see your invention as being something very familiar, but I don't think you can avoid it, right? You can run, but you can't hide. And in fact, if you look at the cases, you will see that there are cases where you get claims invalidated under 101 that are not sort of the standard, oh, it's very familiar, or, this is problematic from a policy standpoint kind of reasons. I'll just give two. One of them, very top of mind right now, because it has been a subject of a cert petition to the Supreme Court, where the Supreme Court asked the solicitor's input, is American Axle and Manufacturing versus Neapco. That was a method for manufacturing a shaft assembly of a drivetrain. There you go. That's not a method of organizing human activity, right? And yet invalidated under Section 101. Another one, ChargePoint versus SEMA Connect. That was electric vehicle charging apparatus. Again, it doesn't sound like a method of organizing human activity, but invalidated under Section 101. And in general, any kind of a computer invention, right? So computers at their base are kind of mathematical, right? They're calculators, they take information, they do some Boolean logic, but at least in principle, any kind of a computer invention, the thing the computer does is something that in theory could be done by a human, either mentally or with a pencil and paper. And there's cases out there that say, oh, the fact that you do it faster, more efficiently does not change that. So there will always be, I guess, an incipient 101 issue to be dealt with, and trying to say, oh, I'm going to change the way I describe this, I'm going to be more abstract, I'm not going to describe it in a way that's familiar. doesn't really solve that problem. And not only does it not solve that problem, but it might raise other problems. So the thing is, patents aren't really just toys for attorneys, right? So clients need to use them, and an approach, the cynical approach that involves obscuring the invention, may work against that. So, for example, if you have a client who is a startup and they're using that patent for marketing, having a obscure patent that does not really reflect their product, because you think their product might be something that lots of people use for everyday things and therefore might trigger 101, that might make it less useful for them as they say, yeah, we have protection for our product, because people say, well, wait a minute, why doesn't this talk about your product? It can make it less good for your clients in their objectives. Also, even setting that aside, it can be less useful as a patent itself, because inventors who have trouble understanding a patent, which is much more likely, I think, if you kind of jigger around with the language, so to speak, are not going to be in nearly as good a position to identify potential infringement or to advise you and say, hey, here's a design around that I'm thinking of. Can we claim to address that, right? The more you kind of focus on the legal rather than the practical in your patents, the less helpful and less involved your inventors are probably going to be, and that, of course, will make the patent less useful as a patent itself, because they're not just toys for attorneys, they're actually business tools for companies, and the companies should be able to use them as such. And then the other problem, so if you're obscuring your invention, it may result in some point of novelty or non-obvious feature that is about your invention, maybe the reason why you're filing the patent, being obscured or omitted. And so you might, even if the cynical approach works, which as I said, it very well may not, just have a cynical approach that succeeds on 101, but gets you in trouble in 102 and 103. And that doesn't really help you at all. So what I would say is, yeah, we do have a flawed system. 101 has some real problems. The law around it has some real problems. I think it, I think it really needs a lot of work. I mentioned that American Axle versus Neapco, the Supreme Court may take cert on that. I think if they do, there's a lot of opportunities to tweak things and make things a whole lot clearer. But at the same time, saying that there are problems with the system, I don't think justifies saying the system is irretrievably broken and there's nothing you can do and it's all meaningless and be basically nihilistic. And in fact, if you do take that approach, what would end up happening is when the time comes, when you do need to deal with a 101 situation, you won't have the tools to do that. So in any case, that's why I think the cynical approach doesn't work. And I guess, again, assuming everything goes according to plan, next in part 3, I'm going to talk about how to synthesize sort of my discussion of what I think is the approach that I talked about in part 2 with the cynical sort of viewpoint from part 1 to come up with what I think is a very logical and effective way of accounting for Section 101, recognizing the flaws in the system, but without being overwhelmed by them. So in any case, stay tuned, and until then, good patenting and good luck.